Whereas one of the main effects of the Supreme Court's decision in the civil rights cases of 1883 was to put an end to the civil rights agenda in Congress of the late 19th century, one of the main effects of the Supreme Court's decision in Brown versus the Board of Education was to provide impetus to a second civil rights agenda in Congress. Beginning in the late 1950s, Congress passed a series of civil rights acts. The Civil Rights Act of 1957 established the Civil Rights Commission, which was given the responsibility for investigating claims of racial bias. In 1960, Congress passed a second Civil Rights Act, which was intended to stop Southern states from denying voting rights to African Americans. While these two acts were important symbolically, they fell far short of the expectations of the leaders of the Black Civil Rights Movement. For example, the Civil Rights Commission may have had the responsibility for investigating claims of racial bias, but had no enforcement authority or ability to do anything when they found evidence of racial bias. The crowning achievement of the Civil Rights Movement came in 1964 with the passage of that year's Civil Rights Act. That legislation prohibited discrimination by government institutions and private citizens in 4 areas: voter registration, public accommodations such as restaurants, hotels, public transportation systems, etc., public schools, and employment practices. With respect to employment practices, the legislation also established the Equal Employment Opportunity Commission, which was assigned the task of ending racial discrimination in employment practices. Subsequent to passage of the legislation, President Lyndon Johnson signed an executive order in 1965 authorizing the EEOC to begin enforcing affirmative action programs. However, it is that second area that we want to invest a few moments to explore a little further. You will recall that in 1883 the Supreme Court had struck down a congressional act that prohibited private individuals operating public facilities from discriminating on the basis of race. The court had held that the Constitution did not delegate that authority to Congress. 80 years later, Congress was taking another stab at it, even though no language had been added to the Constitution giving Congress that authority. As you might guess, a legal challenge to Congress's authority was immediately raised and was taken up by the Warren Court in 2 cases in 1964, Katzenbach v. McClung and Heart of Atlanta Motel v. the United States.